So I'll open it up to questions and stump the lawyer.
All right. So Ben, you've probably seen I don't know how many businesses here in town kind of come and go. If you had to kind of summarize for entrepreneurs what the common theme is, or the things that you see when they come to you and say, hey, we need a legal partner. We were talking about having their legal ducks in a row. What's kind of the common theme that you see as a shortfall for a lot of the entrepreneurs that come to you?
I would say, the three things come to mind right away. The first one is the obvious one. It's a business point, not a legal point. But it's when you run out of money, you're dead, right?
Yeah.
So, as a CEO, the number one thing you can do is not run out of money. And so what I see a lot of is we see people trying to raise money on convertible debt because they overestimate the value of their company. So they say, well, I'll just raise $100,000 from friends and family, but I think my company's worth $10 million, right? So we'll just take this as debt and we won't really value the company right now. That's a mistake because in my view, typically, not always, but because debt comes due at some point, right? And when it comes due, people have an expectation that they're going to be paid. Versus if you tell them, hey, I want you to invest in my company, and but only if you're a credit investor, or you can light a match to this money, then they have an expectation that, hey, this really is what it is, which is a speculative investment, and it's a startup. Most startups fail, and if you can't afford to lose the money, you really shouldn't do it. So, don't set your expectations too high with investors who don't run out of money. That's number one. Number two is we see a lot of people who take shortcuts on employment activity. And by that I mean they treat people as contractors rather than employees. And that does, it's very hard obviously to go through the payroll process and actually set something up, but that is actually how you start. And those people, if they're working full-time for you, really are employees. And in the worst case situation, you can have situations where you paid a contractor and then they don't pay their taxes for some reason, and the IRS can come back against you. So not only do you pay that person, and not only does he or she not pay his taxes, but then you get to pay the IRS the taxes as well. So you've sort of double paid your person. And so, what we like to see is, hey, start low. I mean, even if it's paying minimum wage or something, get a payroll going, get good employment contracts that assign inventions and get stuff inbound, and treat that importantly, almost as importantly as your idea, because we do see a lot of lost founders or people that come back for claims, or in one extreme case, we saw a guy who had been vice president of sales for years and years, come back a few weeks before an IPO and say, hey, what about that 7% of the company you promised me that night at the bar, right? And literally we had to put it into a prospectus and begin litigation. So
You see a lot of complexity in startups with, they don't have the cash to pay salaries, so they'll give you 10% of the company, and then you wake up one day and you've got 9 partners.
Yeah, never talk about percentages, always talk about numbers.
Okay.
Because percentages are treated as non-dilutable. And what does 10% mean, right? If I have 100 shares, do I give you 10 shares or do I give you 11 shares? So that you have really, because once I give you the 10, you've got 110 shares outstanding.
Yeah.
So to make you a 10%, I really have to give you 11 shares. So, talk about numbers, figure your capital structure. Capital structure is just like a cash budget, and you have to budget out for stock. How much money am I going to raise in this round in year 2? How many employees am I going to need? And obviously it's not going to be right. No projection's ever right. But you got to start with a plan and then deviate from the plan and kind of rudder the ship. So the third thing is we consistently see people, and this includes all the way up to venture capital funded people, overestimate their ability to want a trademark, I guess is what I'm saying. In other words, people become wedded to a name for some reason without really doing a search, can I really use this name? So, this has happened maybe 4 times in the last 5 months as people start using a name. They come and see us. We do 5 minutes on the USPTO website, and all of a sudden there's an obvious conflict. I'm like, well, I can distinguish this, I can distinguish that. I'm like, you have a multi-billion-dollar company, that's got a mark that's very close to yours. Do you think they're going to just let you, go away? They have money. They're bigger than you. So, don't pick a fight that you don't need to. And particularly if you're going to spend, 2 years developing a mark and filing and all the marketing materials, it's like, pick the right mark. And so, on that front, it's, pick something fanciful, pick something that's totally inventive. Just make sure that you're in the clear, and then match it up to, of course, the domain that actually works too. Domain name law sort of follows trademark law. So, if you can get a domain that's, close to your trademark, obviously that's ideal. But don't overestimate a mark, or don't get wedded to a mark. There's a lot of other things. Obviously, the main thing about raising money are the securities laws. And brought down to its essence, the securities laws have two components. There's a registration component, which I'll talk about in a second, and there's an anti-fraud component. And if you just always think about it in those two broad categories, that'll get you, 90% of the way there in the securities law. The registration component says you can't have a public offering unless it's registered with the SEC. So this is Zynga today, right? Zynga went public today. And they, obviously it took them a lot of time and effort to get where they are. And they have a filing with the SEC that says we can offer these securities to the public. And of course, there's a prospectus that goes with that discloses every material fact about the company. And that prospectus has been vetted by the SEC, for months now. So if you conduct a public offering, you could go to jail. So that's an important thing to remember is, if you say on the internet, hey, everybody buy my securities, all of a sudden you have a public offering, maximum you could go to jail, minimum you'd have to, if you took money, you'd have to offer those people a rescission offer, which would say, here's your money back, I'm offering you to take your money back, and in exchange for your shares, right? Well, so that's terrible because you've already spent the money on something. So, and even interesting, and nobody remembers this about Google, but Google had to make a rescission offer right before its public offering because they had offered their employees too many shares, that weren't in accordance with the exact exemption. So of course, no employee took that offer, but they still had to make the rescission offer. So, no public offerings, no public forums. So you have to have, talk to a lawyer about what the private placement exemptions are. The second prong of the securities laws are the anti-fraud rules, and those basically say you have to disclose every material fact. Okay, it's really that simple. And the question is, well, what's a material fact? And the material fact is what an average person would want to know if they're making an investment, right? So, if you're a founder and you're licensing your technology or your company instead of having made a contribution of that technology, that's something that somebody would want to know, right? Well, what terms could the license be pulled back, and not remain in the company? Other things are like, hey, I promised my sister, 10 shares of stock. Well, somebody would want to know that because that affects the cap table. So just think about it, and the great thing about the anti-fraud rules is if you flip them over and don't use the term anti-fraud and you just use disclosure and really what I call insurance, you think of it that way. Disclosure is the cheapest insurance in the world because we're in a disclosure regime in the United States. So when you tell somebody, hey, there is this problem, first of all, people feel a lot better because they people know that there are problems. If you're talking to you about an investment in a startup, they're familiar with the world. And secondly, if you tell them, you basically inoculated yourself. You basically have said you've complied with the anti-fraud rules. We told you everything about this problem. You now understand it. Go make your decision. Last thing I would say on that front is this is sort of just a statistics thing. If you have 35 investors, the chances of 3 of them being pissed off increase greatly, right? Just the law of large numbers. So, keep the number of investors and shareholders you have down so that, you're lowering the rule of large numbers about people that maybe didn't have the right sensitivity in, sort of investing people. So, that's a long answer with about five components.
What you were just talking about revolves around initial public offerings, but the same thing applies to private equity.
Absolutely, yeah. This is the key thing, and you know what's a security is actually quite broad. So promissory notes are securities. I mean, you're in the same boat. I mean, you can go to jail for promissory notes. There's very few promissory notes that are exempt securities, and those are mortgages, things that you would traditionally associate with banks, commercial paper. So if you break down the registration rules into two other components, you have exempt transactions and exempt securities. So exempt securities, things that don't have to comply with public offering rules, are things like treasury bills, commercial mortgages, things that you would expect. Well, I don't get to expect this when I get these, right? And then there's exempt transactions, and every offering of securities that's not an exempt security, that transaction has to be exempt. Meaning we're looking at, a period of time and what you're offering. And typically, Rule 504, for example, would say we can raise up to $1 million in a 12-month period, and we can include some unaccredited investors in that. And so you can have people that aren't $2 million people necessarily, but you have to comply with that rule. Then the rule puts you into a safe harbor for that transaction as long as you have good paperwork with purchaser questionnaires, and you file a Form D after you've done the transaction. And then you sit for 6 months and wait for the next offering. After that 12-month period, you have to have a period where there's sort of a rest time. Otherwise, transactions get integrated together, and you have to make sure that two transactions would comply with one exemption. Okay, so there's a time component to these, private placements, and if you have placements integrated together, then that might blow your exemption. So typically, in the best case, what you always want to have is all accredited investors, because first of all, they have a lot of money. Second of all, so you can raise money from them again. Second of all, there's more exemptions available if you have just accredited investors. Did that answer your question?
Yes, thank you.
Ben, what if when you're looking at your pool of potential investors, you do have a collection of unaccredited? Is it important for the company to have additional paperwork to protect not just the company, but the unaccredited investor, or maybe from the unaccredited and the accredited investors? Is there a separation between how I should integrate those two investor pools? I mean, is there...
Everybody should get the same disclosure.
Okay.
Under Rule 504, the exemption that I just talked about, the $1 million exemption, there's no mandated form of disclosure, so you flip into just every material fact. There are some rules that require that say what the form of disclosure is, and basically that becomes a prospectus. It becomes very, very hard. So typically you'll have in a venture capital deal, for example, your disclosure materials will be a due diligence log that you can load in a data room or something else. It'll be every material document that the company has, and people will be able to, that have given you purchaser questionnaires that you have reason to believe are accredited, go in and look at that and vet those documents, and then those get sort of restated in your purchase agreement. And the purchase agreement, unlike a typical subscription agreement, has promises. And it's got maybe a set of 25 promises. We're organized in Colorado, and we're in good standing in Colorado. Mm-hmm. Our shareholders have approved this deal. When we sell you these shares, they'll be fully paid for, unencumbered, except for the security laws and whatever else is in the other documents. These are our financial statements. They're true and correct. If they're not true and correct, why aren't they true and correct? We'll have a disclosure schedule that talks about why that rep isn't true. Sometimes you'll say, on IP, right? You'll say, well, our intellectual property doesn't infringe anybody else. Wow, with all the patent trolls around, that's a sort of a dangerous statement. So you may say, to our knowledge, without investigation, our IP doesn't infringe, and you just tell the person, hey, we haven't done a search. We don't really know, right? But what we do know, we'll tell you, and that is that we don't think we infringe anybody, in the U.S. or anywhere else. So, that's the kind of that kind of disclosure is the best, and that's what happens in a typical venture capital deal, is you run through those list of promises, and of course, every time you do that with a founder, you're like, oh yeah, I didn't think about that, is this a ERISA plan, is this, so there's a lot to think about, and you just sort of check it off. But once you do that the first time, you're sort of ready for the next deal, because, it's just a modification and sort of an updating of what you've already done. So the long and short of it is, if you can do a venture style deal, that's better because it sets you up with these unaccredited people into, one, a full disclosure regime that's sort of, fully vetted. And second, it looks better optically for the next people, like, oh, hey, these people, even though they had unaccredited in this separate transaction, they got their act together, got this done the right way. Otherwise, if it's a true friends and family round, we're really talking about, your brother who's never going to sue you. You would still do all the disclosure, but it might be a sort of subscription agreement or something different in the founder stage. Yeah.
Are you familiar with the House crowdfunding bill, 1394?
No, I'm not.
It's because he just made it up.
So now, so there's a House resolution that they put forward to support crowdfunding. And the basic concept is that unaccredited investors allowed to invest up to 10% of their annual income if a entity declares we're doing crowdfunding, and they can only take up to $2 million total, and I'm trying to remember it, and a maximum of 50 investors or something like that, and a maximum investment from anyone of 10,000.
And there's like a timeline being associated for the next time you're allowed to get money.
Right. So they're trying to set all kinds of provisions, but they are definitely trying to open the window for broader speculative investment. I've talked to a lot of lawyers who are definitely afraid of this and say it's going to end up as a train wreck.
Well, for a place like Colorado Springs, that would be great, as long as, in my view, if I were to pass a crowdfunding bill, and, this is political then, not legal then speaking, I would say 50 to 60% of the problems that I see a year after a fundraise, something could have been solved by having an audit. If you had an audit pre-funding, whatever that problem is would have showed up, could have got fixed then at the time of the offering. So I could see a scenario where I would like, crowdfunding, because, as small businesses get disintermediated by financial intermediaries from, real money, it becomes really, really hard. And of course, America, is a land of opportunity, and without money, there's no opportunity. So I would like to go back to, something like that. Again, subject to full disclosure, maybe subject to some audit rules, or maybe even some simplicity rules. The thing that I sort of grouch about for founders, if I could have my dream world, I'd have a world where it's just common stock, right? And because when you sell preferred stock to a venture capitalist, well, you're layering their money on top of your money. So it doesn't seem fair that sort of money is more important than the hard work that a founder put in. So why aren't you at an equal level? And the answer is, institutionally, there isn't a venture capital in the world that will do a common stock deal. And of course, their argument is, well, the reason we're doing this preferred stock is, we just want our money back first, and we're not there every day watching over, our money. We just gave it to you for you to watch. And of course, you get the upside by still having cheap common stock options that you can give to employees that have more upside than our preferred stock. So that that part of it is true. But if you push it to its logical extreme, like a Zynga or Facebook, well, that Zynga or Facebook is a multi-billion-dollar company even before they're public and before anybody's liquid. So somebody who's getting an option at Facebook today maybe has a strike price that's a $80 billion valuation. So is there really upside in that option? I don't know. And so the way the public market sort of thinks this is people like Microsoft say, we're not giving stock options anymore, we'll just give you the stock, right? You pay the tax. In a private company, that's harder because you can't get liquid. So the employee ends up paying the tax. They still have an asset that, basically they pay 40 cents on the dollar for it, but it's not any speculative. So I would like to see something like that, maybe with, as long as it's all one class of stock, voting common stock, and they're all together, that, that might work.
I haven't heard of that. That's interesting. Yeah, there's a whole website on it, a bunch of stuff. So maybe I'll send it to the Startup Springs guys and have them post a link.
I doubt it'll pass. My instinct would be is there's too many embedded forces for it to pass. And even the changes that people were proposing to make Sarbanes and Dodd-Frank a little bit easier, they were mostly geared towards higher financial institutions, sort of forgetting people with this, right? Forgetting that the little guy really matters. So I'm pretty down on where we are in the securities laws. Yeah, there used to be, nobody knows this. I'll just say this, and you guys can stop me if I'm boring you. But it used to be in the 30s that there was a rule called Section 16 that they passed, and Section 16 said that as a blanket liability, if you're an insider, meaning you're a 10% owner, a director, an officer, if you had a purchase and a sale and you made a profit on that within 6 months, you had to automatically disgorge the money to the company, no matter what, even if you didn't have any inside information. So it was just automatic matching, right? Because they just figured, as an insider, you know what's going on. And if you make a profit in a short period of time, something's tricky, right? Well, since the 30s, that rule has basically been gutted. And basically how it's been gutted is they created a rule called Rule 16b-3 that said, except for stock option transactions, under a stock option plan, right? So that's what we've seen in the growth since the 70s is everybody realized, oh, we got a 16b-3 exemption. And so now you have these giant, stock options like the one that the Disney guy exercised years ago for hundreds of millions of dollars and then sold it the next moment. So you exercise, sell. You have a matching transaction, but now you have a rule that's an exemption. So, that's kind of you've taken what was a rule, you totally perverted it so the exception swallows the rule over a 60-year period.
From that standpoint, with your political hat still on, what do you think about Congress's exemptions in this area?
Oh, and there's, they should be subject to all the security rules. I'm shocked that they're not. Really? Well, I'm shocked that anybody would actually act on it, I guess, as a congressman. I mean, knowing that they have disclosures, it's crazy.
So kind of the common theme in Colorado Springs is we hear a lot, there's no VC. I'd be curious to hear your thoughts on, in your years here in town, kind of the typical, or I guess the typical funding you see for startups. Is it a mixed bag? Is it mostly VC? Is it friends and family? Is it traditional? Is it angel?
It's changed over the years. When I got here in 1994, there wasn't any VC money, so it was all just sort of friends and family. As we went into the internet period, we had a bunch of very good VC funding. If you look back, there was Channel Point, there was Telsoft, it's all funded by national VCs. The problem is none of those ended up going public. And so then, of course, we had a dearth of VCs, and there were some local efforts that sort of had some mixed results. And then there, so what we see are mostly angels and super angels. And that is a little bit of the trend now, even in California. There are super angels that are sort of at the lower VC, at the end of the lower end of the VC spectrum. And I think those people are really interesting. I think they're really what drives the economy. Those super angels. They're really the ones that are visionaries and they can sort of see out in front. And it just happens to be there's a lot more of them in Silicon Valley or in Denver or Boulder than there are.
Yeah.
My favorite deal, if you're really savvy enough and you can really pull this off and you have some good technology, meaning probably a patent, the best deals that I've ever seen are strategic deals right out of the box. In other words, where somebody really has an industry background and they can go to an industry player and say, we want you to invest. Because if you're a storage company and you want to, and IBM's an investor, then automatically VCs will be interested. And of course, then you have to address the, well, then why, in that scenario, why wouldn't IBM be the only acquirer? And then you have to say, well, so many people will be interested in this. There was a guy in California when I worked in Silicon Valley that basically got four competitors. There were basically 4 people in the world that were in this industry. They all invested, and they all made so much money that the equipment that they bought from this person was free for years because they made the strategic investment. They used the equipment. that company went public, of course, they had a lot of money, owning those shares. So, the best scenario would be two competitors invest in you, and then you're really off to the races.
The financial cost of doing anything, super angels, what have you, can be considerable.
Yeah, I mean, it's this is too categorical statement. Everything's sort of a bell curve, okay? I'll just say that, right? I mean, you got this like this, right? And so securities are a bell curve too, right? On this end, you have totally secured debt, and then you've got, into preferred stock that's maybe convertible and redeemable, and then you've got non-redeemable, and then you've got non-convertible, and then you've got common stock, right? So everything's, it's kind of this range. And the same is to cost in doing deals. I mean, a venture capital deal, can cost a lot of money. Typically, they don't. But in a really difficult transaction that's would require recapitalization or something else like that, you've got these outliers of cost here, and then you've got really simple, founding deals where you've got just one investor that is just trying to get something done. Those don't cost a lot. So it just depends on the level of complexity. And when founders come to me, it's like, okay, do you want bypass surgery? Because that costs more than Lipitor, So you pick. If you feel like, we could tell you need bypass surgery, and you say, I can't afford it, then you say, okay, well, here's what you need to do to try and cover yourself. Because, of course, as lawyers, we always get the question of, is it okay if I, right, and then fill in whatever, and then you have to say, well, it depends. And then you have to factor in what it depends on. So,
Ben, on complexity and cost, there's been some good efforts out there for model documents and standardize some of these things. Last I checked, the problem was there were maybe half a dozen good ones and 50, not one tier down. Are you seeing any?
A little bit, yeah. I haven't had clients actually request them yet, and I haven't had a VC request them yet, interestingly. But I did use a National Venture Capital Association, model document recently. I mean, the great news about the internet is, there really is a lot more data out there to figure out, what the norms are. And I would encourage any of you to go to the Fenwick and West site if you're really, interested in VC deal terms. They actually have a database that tracks quarterly Silicon Valley deals, so you can figure out how many deals were participating preferred, how many had a 2x liquidation preference, how many were up rounds, how many were down rounds. And so it's sort of a little bit of a VC barometer, which would have been unthinkable in the old days. So, because of course what you hear from lawyers is, we always get this term, and then like, well, we never get that term, and then it's like, okay, the lawyers are fighting, so it's not good. So when there's actual data, and this is actually true in M&A transactions now, is they actually track M&A data, how much pullback, how many escrows, so that kind of stuff has been really helpful.
So do you like the VC Association's model docs versus TechCrunch has theirs out?
I've actually looked at both, and depending on the situation, we would select different things. TechCrunch's or Y Combinator sort of documents are simpler, so they're missing some points. And so maybe it's good that they're missing those points because nobody cares, and maybe it's not good because somebody does care. But on the other hand, yeah, I know, it's hard. Yeah, you can't categorically. I generally prefer simpler. If you look at, for example, registration rights, you can have 2 pages of a term sheet cover registration rights, and the number of demand registrations we've seen is 0 in 21 years. So why argue about it? If you never see it, why argue? Everybody thinks, well, we'll be the exception. Somebody's going to force us to go public. I'm like, probably not.
So Ben, I've got a big roundabout question to ask. As a first-time entrepreneur, me and my co-founders are constantly focusing on the business and getting the product ready and everything like that. And so many times we really feel like the legalese side of the business gets the last penny from the dollar often. And so we work with David Sarwal at Sparks, and he's been just an amazing asset from like a Q&A perspective and such. But whenever I do engage with him, I'm constantly questioning whether or not I've done enough homework to talk to him about it or whatever, or am I asking him a question that's 19 miles ahead of what I should be asking him. Him and I kind of have this question and answer session going on about a roadmap of like where we should really be. And it's difficult for us to, I guess for me, for not having a legal perspective constantly, to really know where I am on that roadmap.
Yeah.
So can you talk a little bit maybe about how Sparks engages with entrepreneurs to customly create that roadmap? And if there are giant blocks, I mean, we always talk about venture capital and like where people get money or whatever, but there's so many things that have to happen before you can get there.
Great.
And those steps are the ones that you can just do a Google search for and find all the documents, but to lay the Legos down in the right order is just as important.
That's a really well-worded question. Interesting. So after many attempts to sort of try and figure this out, I started to do what some people do, reverse engineer, right? Okay, well, what is success? Well, success is an acquisition, okay? So what happens at an acquisition? Well, the first thing that happens is you get a due diligence request from the acquirer. It's 400 pages long, right? And deals are much harder to get done now in terms of acquisitions than it used to be for a number of reasons I can talk about later. But anyway, if you take that due diligence list, it's everything that every company ever needs, right? And so the question is, well, as a startup, what of those do I need and when do I need them, right? So what I've tried to do is I've tried to pare back that due diligence request using that sort of formula, because there is sort of a standardized way that people are asking these questions. I mean, there's 10 litigation questions, there's 20 IP questions, and you sort of move that into a simplified kind of due diligence form about, well, what do I really need? And then you just start indexing documents, articles of incorporation. We know those are going to change, you're going to have 4 of those. Bylaws might change a little, but not, right? Then you get into founder employment agreements, restricted stock purchase agreements, 83B elections, IP assignments, trademark, right? So if you start slotting in documents into that pared back due diligence list, you're building a pyramid sort of out to the rest of those documents in a form that everybody understands. So what we're trying to do with people that want it is basically sort of a modified continuous diligence. Is we can load it up on BitWeld or some other data site and everybody can access it, and you actually know what your documents are. Now it's really a discipline to keep that going, and what I found is that CEOs don't like that discipline, but CFOs are great at it. So I like CFOs because they like, hey, we got this problem, we're hiring somebody, here's the documents, right? You do the documents, you load them in a BitWeld, and you get going. And even people that have, so that's kind of what I would do is try to sit down with Dave or your lawyer or somebody and look at that due diligence list and figure out, do I need this now? If the answer is no, then wait. But I know I'll need it later, so when are we going to need it? And sort of plan out like, when we're going to have to implement something like that.
If you go with Sparks WIllson, Ben's assistant will do it for you, and it's just a beautiful thing.
Yeah, we do have a really good paralegal too.
So I had a kind of a piggyback on Ian's question. It seems like entrepreneurs, they start their company, put their business plan together, and everyone tells them, okay, you got to get your legal team, you got to get all your ducks in a row, all your paperwork. And then once that's done, it's easy to forget.
Yeah, right. That's
so,
the key.
yeah, right. And I guess my question is, in our case, we've been around for 10 years, and we kind of did what most people do. We get our legal team when we start, and then we forget about them. And then when shit hits the fan, we're like, oh, we need our legal team again. And it's almost a hired gun mentality, which we learned after about 5 years that that's not the way to do it, where you build them into your team and you use them on a regular basis and proactively. Maybe you can talk about the importance of that ongoing
I would say
partnership, I guess.
Right. So, with our best clients, we meet with them quarterly to start out with, so that the company can get into a rhythm of knowing that it needs the documents and can sort of stay on the path until they're big enough to kind of really need us at a board meeting. But I would religiously schedule board and shareholder meetings, because that's what drives decisions and that's what drives documents. And then you've got a good corporate process to sort of protect you, and you've got your people engaged, lawyers and accountants. I would say, we've definitely sort of the accounts are probably more important than us in many respects. And so you want to keep them in the loop, make sure you're booking stuff, and if you need GAAP financials or if you need certified, or audited financials, that you're ready for it. So that's what you've changed over to, is what I would say is the way to do it. And we see that all the time. People say, yes, we're going to do that, and then they forget.
Yeah.
And when we remind them, they're like, yes, we'll get to it, but we can't afford you, or, we're too busy. So I've got a shareholder meeting at 9 o'clock, so I got about 5 more minutes for questions.
Here, I'll give you a softball one, I think. Corporate structures, right? So I get the question all the time, how should I start a business, right?
Yeah.
Everybody thinks LLCs are the easy one, and I always tell them if they, because I'm not a lawyer, I can give advice for free. If you're going to take money at any point, you should be a C Corp. Just from a structure perspective, it'll give confidence to investors. It's easier to deal with long term. If it's ever going to be anything, it's going to want to be a C Corp.
In the world that we operate, I would agree. That's not always the case. I mean, particularly if you're buying real estate, or you're doing a venture fund, those structures really do require a different, partnership tax regime. But
What state? Do you guys have a strong preference? Is Colorado okay, or Delaware, or Nevada, or something?
I think Colorado's okay, and the reason I think Colorado's okay is in 2004 we were able to get the majority shareholder rule changed to be the same as what it is in California, Texas, and Delaware, New York, and a lot of other places. Basically, that means that shareholders can take action by less than unanimous written consent as long as you get this approved and in the articles, right at the beginning or sometime later. And what that means is that if you've got 25 shareholders, you don't need all 25 to sign something which you used to have. You can have, a majority, and then you send out a notice that people who didn't sign and say, hey, the shareholders did this thing. That lets stuff happen more quickly without necessarily meeting everybody. So I think Colorado is a better place. With respect to the tax question, some people, if they need to pass through losses, will start with an S corporation because it's easier to convert to a C corporation. I actually like C corporations from the beginning, even though there's potential double tax on an asset transaction. C corporations, have a lower tax rate at the very low levels of income, so they're sort of a good place to start building up some cash. And you don't have to do K-1s and do distributions to people. So I think, if you're really serious about wanting to be something later, like a big tech company, then you should start as a Colorado C corporation. You might be required to reincorporate, but the time and expense of Delaware isn't worth it for most people in my experience. And many of our Colorado C corps have been acquired without any question from the acquirer.
One last question for me. Ventures fail. Getting out of whatever corporation you're in, is there pitfalls?
Yeah, I mean, that could be a 3-day session. Ventures fail. Interestingly, there's a book called Why Things Fail, and it basically says ventures fail at the same rate as species, just on a much different time scale, right? I mean, so everything fails. I mean, we know that. It's by definition, everything fails. And so you do sort of have to figure out, well, what if I fail? How does that happen? And this is where the debt question that I mentioned earlier comes into play is, typically what in a well-funded venture that people know it's going to fail. I mean, we've had investors put in money basically to just shut it down, right? And that means scrubbing the facility and paying all the severance. The typical pitfall and failure is employees don't get paid. And what you really want to avoid is that creates a lot of bad feelings. And you really want to avoid that. You want to be able to pay everybody's accrued salary. I mean, even if it's the worst case of telling them the day it is, at least you'll have a check for them. So if you have to project out for failure and be ready for it. Because if you do fail, and you can't pay people, then that raises the specter of people get mad, they go to see a lawyer, is there fraud, is there some other problem? So the technical ways, there's a Colorado statute authorizes a dissolution, and the dissolution happens where you go into bankruptcy voluntarily or involuntarily. It's better to avoid bankruptcy. Of course, in bankruptcy, inside creditor payments can be recaptured by the trustee. So, you know, if you're paid yourself something and you end up going bankrupt, the bankruptcy trustee is going to come see you and take that money back. So you kind of want to try to avoid stuff like that. But do all, you know, you should always have that in the back of your mind. You know, could I wind this up and would everything be okay? Great. Well, thanks for having me. And you know, just everybody, you know, feel free to call me at the firm. I typically like to sit down with people and get to know them before we get engaged. So, you know, it's a 30-minute kind of session where we just sit and talk, and then we to get formally engaged, we send you an engagement letter. Typically, if we don't know you or you haven't worked with us before, we do require some retainer. Otherwise, it's sort of, we feel like you're not really invested in us, you're just sort of using us. So we would ask for that. The retainers that we typically ask for, we apply against the bill, so it's not something, I mean, it's just to sort of make sure that you really want to use our services and then we apply it against our services. But we love startups, and you know, it's our bread and butter. And for me, intellectually, you know, my college degree is in history of science. So, you know, working with people that found companies, it's just, you know, that's why I say a lawyer, is because it's interesting to work with, you know, people that have great ideas. So get out there and do it.
Ben, thanks for coming out.
Great to see so much energy in the group.